The National Industrial Court has fixed Wednesday, 21st September 2022, to decide on an application by the government seeking that university lecturers resume work. The court on Monday began hearing on the application by the federal government seeking that the Academic Staff Union of Universities (ASUU) resume work while awaiting the decision of the court on their 7-month-long strike. Justice Polycarp Hamman presided the hearing after ruling against a preliminary objection against same motion by ASUU, noting that the court is meant to hear the application by the government as against the defendants. Justice Hamman gave this position after setting aside an application by ASUU through its counsel, Femi Falana, opposing the court's hearing of the federal government's application. The court further noted that the preliminary objection was not yet ripe for hearing, adding that the rule of the court has The court further noted that the preliminary objection was not yet ripe for hearing, adding that the rule of the court has provision to hear both the preliminary objection alongside the main suit. In arguing the application, James Igwe for the government said Section 18, subsection 1E of the Trade Disputes Act provides that employees cannot be on strike when a matter is before the industrial court. Falana, however, said a referral from the Minister of Labour seeking an order of the court asking ASUU to return to work amounts to ordering the industrial court, a power which he says the Nigerian president does not have. Counsels of both parties in the suit later spoke to newsmen on the direction of the case.
When the matter came up this morning, we informed the court that we're ready to go on with the application, the business of the day. However, the learned counsel for the ASUU said he had filed another application for a preliminary objection, which was served on us right in court at about 11 a.m. And we told the court that application was not ripe for hearing. What was ripe for hearing is the application for interlocutory injunction, and we argued along those lines, and the Honorable Court agreed with us that indeed what is ripe for hearing and what is slated before the court is the application for interlocutory injunction. And we took the application extensively, argued on it, and they responded. The court has reserved a ruling on that application for Wednesday, 21st of September this year. And what we're all saying is that the ASUU needs to be restrained, considering the irreparable losses minute by minute, day by day, that it's irreparable losses, unquantifiable damages that are being done to the educational sector, that while this matter is going on, that the court should restrain them at the moment, let students go back to school, let innocent students, millions of students who are not parties to this matter, go back to school, while the issues are being determined or adjudicated upon by the Honorable Court. That's all we're saying.
We have addressed the court to the fact that the Minister of Labour ought to have taken this matter to the Industrial Arbitration Panel, so that, we can have this matter resolved there. But now that we are here, we've addressed the court to let the court know that the position of the law. But again, as I said, our clients are most willing to have this strike called off today if the government will at least consider the interests of the students and the national interest. And we hope that the intervention of the House of Reps tomorrow will go a long way to addressing the issues that are still left untouched. An agreement has already been reached. What our clients are asking the government to do is to dot the I's and cross the T's. The government wasn't satisfied with the recommendations of the Jubilee Committee. It decided to set up another committee headed by Professor Briggs. Incidentally, Professor Briggs led the committee of pro-chancellors that met the president last Friday. So we hope that we are getting to the end of the strike.